Talk Shoes. Recorded live.
Welcome, everybody, to our Wednesday night conference call, The Free Americans. It's a conference call we do every Wednesday night. And our special guest is Christian Walters, and we're talking about the Gilbert Law Summaries on Trust. Before we get started tonight, I'm going to read our disclaimer. This show is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making legal decisions. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show is for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show, you understand with agreement that with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of the herein reference, and has no interest in any issue referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaison to communications between the parties. By listening to the call tonight, you acknowledge and agree that you are not a client of Christian Walters. The show recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. All right, folks, with that said, I'm going to go ahead and turn that over to Christian. Christian, you've been unmuted. Go ahead.
Okay, thanks, Matt.
You're welcome.
Welcome, everyone, to this Wednesday, March 10th edition. Welcome to NTT, New Trust Technology, in relationship to what we're studying. And what we're studying is Gilbert's Law Summaries on Trust by Edward C. Halbach, Jr. And we're picking up on page 218 of the book under Section D, Trustees' Liabilities and Beneficiaries' Remedies. So here we are talking about two important parts here, trustees' liabilities and beneficiaries' remedies. This is what we wanted to really get to. So we're starting off in Section 781, which is standing to enforce the trust. If a trustee has breached a fiduciary duty, only the beneficiary or a successor trustee, co-trustee or guardian, or other person acting on beneficiary's behalf can complain. Outsiders have no standing to enforce the trust and cannot hold the trustee liable for duties that do not run to them. Even the settlor can complain only if he is also a beneficiary. Although this rule may be changing, and you want to see the restatement of the second, Section 200. Although this rule may be changing usually by statute, especially in the case of charitable trust, and see Supra, Section 508. Number 2, beneficiaries' remedies. Equitable relief. A. Number 1, suit to enjoin or compel. Section 782. The beneficiaries may institute suits to enjoin or instruct the trustee or to compel proper performance of particular duties. Number 2, suit to remove. Section 783. In appropriate circumstances, example, serious or repeated breach, the beneficiary may obtain a court order removing a trustee or one or more of the several co-trustees, or may deny or reduce compensation for the period involved. Number 3, constructive trust, Section 784. Where a trustee has misappropriated trust assets or used trust funds to acquire other property, the beneficiaries can enforce a constructive trust, tracking the property and requiring it or its proceeds and the profits from the property to be used exclusively for the trust and its beneficiaries, or enforce an equitable lien on the property to secure a claim for damages. So there's two remedies, an at-law remedy there and an equitable remedy. B, damages, Section 785. Where damages are sought by the beneficiaries, they generally may be measured by the following principles. See restatement on the second, sections 205 through 211. Number 1, in general, Section 786. The trustee is personally liable to the trust estate or to the beneficiaries directly, depending upon the circumstances, for any loss or depreciation in value of the trust estate and loss of income resulting from his breach of trust, plus interest. A growing number of modern decisions have recognized losses as a trustee's failure as a result of making proper and improper investments, example, by not diversifying or by excessive conservatism, including favoring the income beneficiary by investing excessively in bonds, to achieve the gains proper investment should have produced. And you want to see a couple of case sites there in support of that. So this recovery for lost profits is expressed as restoring the trust estate to what it would have been if it was properly administered. See Restatement the Third, Prudent Investor Rule, Section 211, Section 211, subparent 2. Number 2, failure to make property productive, Section 787. A trustee has a duty to make the trust property reasonably productive. This term is usually used to refer to productivity of a reasonable amount of income, that is yield, but the duty is in its broader but less frequently used sense includes total return, often just return, that is income plus other return, mainly in the form of appreciation in the market value of principal. A trustee who fails to make funds productive is liable to the adversely affected income beneficiaries and to the trust or its remainder beneficiaries. See generally supra, Section 786. Number 3, improper investment, Section 788. A trustee who does undertake to keep their property productive is nevertheless personally liable to the beneficiaries for losses resulting from any investment that is determined to be improper or imprudent under the principles stated above. A. Note: competent beneficiaries who knowingly consent to a particular investment may be estopped to hold a trustee liable for their positions or portions of any resulting losses. See Infra Section 802 and see decisions of principles generally precluding offset of gains against losses, Infra Section 790. Number 4, losses to principal, Section 789. Where improper investment or improper conduct has led to a diminution in the value of the trust principal, the trustee is liable, along with other possible liabilities, to make up that loss. Example, a $10,000 investment of trust funds in X company stock is found to have been imprudent. It is now worth only $2,000. The trustee is liable, traditionally, for the $8,000. But what if the trustee has made other improper investments that have increased in value? Example, the same trustee imprudently invested $10,000 in Y company stock, which is now worth $15,000. A. General rule: gain from improper investment cannot offset loss, Section 790. It is a primary principle of trustee liability that where there are two distinct breaches of trust, the trustee cannot offset the profits from one against the loss of the other. Restatement of the Second, Section 213. The policy of the rule is to avoid temptation or recoup losses or to gamble the gains from an earlier breach by undertaking another. B. Exception: same breach of trust, Section 291. If, however, the gains and losses are attributable to the same breach of trust, absent aggravated circumstances, a court will allow the balancing of losses against gains from that transaction. C. Single breach versus distinct breaches, Section 792. It is often very difficult to determine whether a particular situation involves more than a single breach of trust. Courts generally phrase the question in terms of ascertaining whether the breaches are severable or whether they are substantially separate and independent. Usually two separate imprudent or otherwise improper investments are to be dealt with independently and without offset. The trustee is generally held liable for the loss on the investment that turned out badly, while the beneficiaries are allowed to retain the gain on that one that turned out well. But if the trustee made a single improper investment, part of which could be sold at a profit while the other had to be sold at a loss, his liability is the net loss after deducting the gain. But when there are a series or a set of investments all part of one investment action, Factors to be considered in ascertaining the severability of breaches include whether the same or different portions of the trust res are involved, although this factor is not particularly supported by the policy underlying the rule, whether the breaches arise out of the same or different transactions or out of the same or different investment policy decisions, the length of time between the transactions, and the like. Restatement the second, Section 213, Comment E, and Restatement the third, Prudent Investor Rule, Section 213, Comment F. Number 5, profits, Section 793. A trustee is liable for any profit made by him personally through his breach of trust. The purpose of the rule is to remove any personal incentive a trustee might have to commit a breach of trust even at the opportune time. Example, the trustee improperly borrows $10,000 from the trust and invests it. His successful investments go up in value to $100,000. The entire profit of $90,000 belongs to the trust. A. Identifiable profits, Section 794. A trustee is liable for identifiable profits that would have been made by the trust estate but for the breach. Example, a particular security that the trustee was directed to retain in the trust estate was improperly sold but at its full value, and the proceeds were placed in a bank account. Subsequently, the stock, which had been sold for $20,000, has now increased in value to $50,000. The trust is liable for the $30,000 in lost appreciation that should have accrued to the trust estate, and these facts under the traditional rule on damages. Number 6, interest and earnings, Section 795. The trustee is also chargeable with income loss, that is, net of income received, as a result of the violation of a fiduciary duty. Thus, he is, under appropriate circumstances, chargeable with interest at prevailing market or statutory rates on the sums owing to the beneficiary or the trust estate from the time of the breach. See Restatement the second, Section 207. Next page, 222. Beneficiary's equitable remedies for trustee's breach of trust. Restitution or damages. Number 1, loss or depreciation in value of trust estate due to breach. Number 2, interest on sums owed from time of breach, and profits made by trustee personally due to the breach. And now other equitable relief. An injunction, where the trustee may enjoin from committing a breach or compelled to perform his duties, and that's what I was talking about last night on the call. And removal, trustee may be removed from office for committing a breach, see supra Section 153 through 158. And a constructive trust arises, properly misappropriated by trustee may be traced and applied exclusively for the trust and its beneficiaries. C, relief from liability now. Number 1, effective exculpatory clause, Section 796. The trust instrument may contain a provision to the effect that the trustee shall not be liable for errors of judgment or carelessness, nor for any breach of trust. Such exculpatory clauses are generally given effect by the courts within reasonable limits. And there's a couple notations there on the effect of provision with trust instrument relieving trustee from duty to account. 171, I believe that's probably American Law Review, 631, 1947 edition. A, limited by public policy, Section 797. The clause is not valid or effective insofar as it attempts to relieve liability for bad faith, intentional breach of trust, or gross negligence. Such a provision would be contrary to public policy. Tuttle versus Gilmore, New Jersey case, 1886, where the word careless in the above exculpatory clause is thus in doubt, as negligent probably would not be, and see infra under Section 798. B, narrowly construed, Section 798. In most jurisdictions, however, exculpatory clauses are effective to relieve the trustee of liability for other types of breaches or duties or standards. But even then, courts tend to interpret such provisions narrowly so that, in the case of doubt, the areas within which a trustee may avoid liability are limited. C. No effect on creditors, Section 799. Exculpatory clauses apply to suits by beneficiaries, but not to the trustee's liability to creditors of the trust, and see below. D. Not an expansion of powers, Section 800. An exculpatory clause does not expand the trustee's power or authority or authorize that which is otherwise impermissible under the terms of the trust. The clause merely relieves the trustee from liability for the impermissible acts. Thus, it would not protect third parties who are liable to who are required to make restitution for their dealings with the trust property, nor does it assure the trustee compensation for services in connection with the activities and property undertaken. Now the exam tip. If you encounter a clause in a trust instrument purporting to relieve the trustee from liability for breach of trust, remember that such exculpatory clauses are strictly construed but are enforceable to the extent no bad faith, intentional breach, or recklessness is involved. Now, number 2, consent of beneficiaries, Section 801. Under appropriate circumstances, all of the beneficiaries may modify a trust, at least as long as the material purpose of the settlor is not thereby undermined. Such unanimous action can, and in support of trustees' otherwise impermissible acts, constitute an amendment of the trust, making the trustees' acts authorized. If not intended to amend the trust to permit subsequent acts from the same type, the unanimous action serves to prevent all beneficiaries from surcharging the trustee. They are giving the trustee complete immunity from liability for that particular act. A. Consent from some beneficiaries, Section 802. Absent unanimous consent, the proper consent for some of the beneficiaries serves to stop those who consent but will not impair the rights of other beneficiaries to sue the trustee. B. Consent, Section 803. Here again, it is important to emphasize the full range of duties the trustee has to the beneficiaries. As a result of those duties, courts are cautious in finding an effective consent and require full disclosure by the trustee and the properly informed action by the beneficiary who understands and the applicable rights and alternatives. In addition, some affirmative approval or act of encouragement, inducement, or participation by the beneficiary may be required. Mere silence is usually not enough unless circumstances imposed on the beneficiary are duty to speak. Next page, 724A, Latches and Statutes of Limitations, Section 804. A trustee may be protected by the running of the statute of limitations or by latches on the part of the beneficiaries. Because beneficiaries often do not learn of a wrong for some time, the statutory time period generally does not begin to run during the existence of the relationship unless and until the beneficiary is of age and knows of or reasonably should know of the facts constituting the breach of duty. In some states, however, statute of limitations are held inapplicable to equitable claims, and the barring of beneficiaries' causes of action is a matter of latches. A more flexible doctrine under which the circumstances, as well as the beneficiary's awareness, affect the length of time within which a suit must be brought. B. Effect of trustees' insolvency, Section 805. In general, a trustee's liability may be discharged in bankruptcy, but not with respect to losses caused by fraud, embezzlement, or other intentional misappropriations. Whether a trustee with liability to the beneficiary becomes insolvent, questions of priority may arise among the beneficiaries themselves. Although some earlier cases granted priority to those beneficiaries first entitled to distribution, example, income beneficiaries over remainder beneficiaries, the usual rule today is that all beneficiaries share pro rata in the available recovery. Essentially, this is accomplished by restoration of the funds recovered to the trust estate and then ascertaining, number one, amounts owed to income beneficiaries or others to whom distribution should have been made, and two, amounts properly to be retained as principal. In the absence of a special bias or basis for doing so, claims of trust beneficiaries are not given priority over other general creditors of a bankrupt trustee, although the trust properties are not assets of the bankruptcy estate because the trustee has only bare legal title. C. Equitable relief, Section 806. Traditional doctrine holds trustee liable for breach of trust even where he acted with best intentions. There is, however, a tendency in some courts, under some statutes, to consider in mitigation the trustee's good faith, diligence, and whether the loss was foreseeable, as well as what was reasonable to expect of the trustee, and thus possible to limit or even excuse liability. See Scots on Trust, Section 205.2. Next section, E, trustee's liability to third parties. Number 1, contract liability, Section 807. Under traditional principles, a trustee, as principal, rather than the trustee estate, is personally liable to all parties with whom the trustee contracts in the course of the trust administration, unless he specifically limits his personal liability by the terms of the contract or unless it is otherwise provided, as today as usually is, by statute. See the UTC, Section 1010. This does not necessarily mean that the trustee must actually bear the ultimate loss. However, for he has the right of indemnification against the trust estate for any such liability as long as he acted properly in making the contract. That is, the contract was within his powers as trustee and he acted with prudence. In other words, as long as he has not committed a surchargeable offense. Restatement of the second, Section 262. Of course, the right of indemnification is dependent upon the adequacy of the trust property, and that is why the issue of personal liability matters. It matters particularly when, as between two otherwise innocent parties, here the trustee and the third party, one must bear the loss because the party who should ultimately be liable, here the trust estate, is unable to meet the obligation. A disclaimer of personal liability, Section 808. Under the traditional rule, a trustee may prevent personal liability by expressly so providing in the contract. Number 1, form, Section 809. The disclaimer must be explicit. Example, trustee shall not be personally liable hereunder, quote unquote. Merely signing T as trustee is not ordinarily a sufficient disclaimer, nor is T protected because the other party knew that T was a trustee contracting on behalf of the trust. A, as trustee and not individually, Section 810. But signing, quote, as trustee and not individually, unquote, probably protects the trustee from personal liability. Section B, pursuant to trust instrument, Section 811. A trustee signing a, quote, pursuant to trust instrument of record, unquote, where the recorded instrument contained a provision that the trustee should not be liable for contracts entered on behalf of the trust, has been held sufficient. And there's a case cite for that, where the contract of trustee as basis for suit to reach the trust estate or charge the trustee personally or as trustee, Section 139, American Law Review 134, 1942. C, exception, negotiable instruments, Section 812. A trustee signing or endorsing a negotiable instrument as trustee, quote unquote, for the designated trust is not personally liable as long as the trust is properly identified. The holder of the instrument instead has a direct action against the trust estate, see Commercial Paper and Payment Law Summary, that is normally still requiring suit against the trustee in her fiduciary or representative capacity. Number 2, effect, Section 813. A valid disclaimer relieves the trustee of personal liability, provided the trustee acted properly in the performance of trust duties in making the contract. In such a case, a third party may proceed directly against the trustee in his representative, not personal capacity. A, distinguish, improper contract, Section 814. If, however, the contract was an improper one, example, exceeded powers or was an imprudent exercise of power, the disclaimer is not effective, the trustee remains personally liable, and no action is permitted against trust estate, except that if the trustee is insolvent, most courts would permit suit against the trust estate, probably for restitution limited to the value of actual benefits received by it, in order to prevent unjust enrichment. But see Infra Section 819. B, Waste 815. Well, that's Waste 815. An otherwise valid disclaimer will not be effective where the trustee subsequently commits waste or wrongfully uses up the trust corpus, so that the trust res the creditor expected to reach is not available. A collateral promise is implied that the trustee will not improperly undermine the source of the creditor's payment. Statute Section 816. Legislation in most states explicitly eliminates the personal liability of the trustee as principal. This has not resulted from statutes providing that the trustee is the general agent of the trust estate. Where the common law has been modified by statute, only the trust estate, that is, the trustee in his fiduciary capacity, is liable on contracts properly executed by the trustee if the status as trustee was known to the other party. C, trustee's right of indemnification, Section 817. The trustee's right of indemnification under the traditional view for a proper and prudent contract on the course of administration means that the trustee can either satisfy his personal liability directly from the trust estate, exoneration, or pay the creditor from his own funds and then obtain reimbursement from the trust estate. Number 1 includes cost of defense, Section 818. The trustee's right of indemnification from trust assets includes all costs reasonably incurred in the defending suits against him by third parties, unless the suit arises out of a breach of duty or from some fault of trustee. Note that trustee usually may not charge the estate for attorney's fees in an unsuccessful attempt to defend a surcharge action brought by the beneficiary. Number 2, creditor's rights, Section 819. If the trustee is insolvent, it has been held that the right of indemnification can be reached via creditor's bill in equity or its current counterpart by creditors who he is liable in the course of administration. The right of the creditors is derivative and thus subject to all defenses in trust or beneficiaries would have had, example, breach of trust, in suit directly by the trustee. You must see Mason versus Pomeroy, 24 Northeast 202, Massachusetts, 1890 case. To the extent the creditors had a direct action against the trust estate, see above. However, their rights are not derivative and thus probably are not subject to offset from beneficiaries' claims against the trustee. Number 2, tort liability, Section 820. Again, under traditional common law, the trustee, rather than the trust estate, is personally liable for torts committed by trustee or his agents in the course of administering the trust, with the trustee having the right of indemnification from the trust estate if he was not personally at fault. See Restatement of the Second, Sections 264. A trustee's right of indemnification, Section 821. A trustee cannot indemnify himself from trust estate for tort liability where he was personally at fault, either for intentional or negligent torts. If not personally at fault, however, indemnity also allowed. And see In Re Estate of Lathers, 137, miscellaneous 222, 1930 case. Number 1, where proper, Section 822. Exoneration is allowed a trustee who is not personally at fault for, number 1, torts committed by agents selected and supervised with reasonable care to undertake duties that can properly be delegated. Number 2, torts based on absolute liability. And number 3, torts committed by trustee as a normal incident to the kind of activity in which the trustee is properly engaged. That is, a trustee's running a newspaper has been held not liable for inadvertent libel. Number 2, where not proper, Section 823. But indemnification is not proper where the loss resulted from the trustee's breach of duty, in which case the fact that some third party actually caused the harm or damage is immaterial. Example, the trustee operating an apartment building in trust fails to obtain liability insurance under circumstances that constitute a breach of duty. A visitor to the building falls under circumstances rendering the trustee personally liable for janitorial negligence. The trustee is not entitled to indemnification because the loss should have been covered by liability insurance, for the lack of which the trustee is personally and ultimately liable. B. Charitable trusts, sections 824. The older cases held that trustees of charitable trusts were not personally liable for torts committed by agents selected with due care. McDonald versus Massachusetts General Hospital, 1876 case, overruled by Colby versus Cary Hospital, 1969 case. But the modern trend of authority is contrary. Trustees of charitable trusts are liable to third parties to the same extent as trustees of private trusts, that is, for torts committed against or by agents within the scope of their agency, respondent superior, even when the agents were selected with due care. In the Myers versus Donza case, Nebraska 1966 case, if a charitable institution, that is a hospital or college, is trustee, its directors or board of trustees are not the trustees, the institution is. Now the little block there, the trustee's liability for contracts made and torts committed within course of administration, where the contract liability is the trustee personally liable to third parties. The traditional view, yes, unless the contract specifically provides otherwise. The modern view, no, only the trust estate, that is, the trustee and his fiduciary capacity, is liable absent personal fault of the trustee. And may trustee seek indemnification from the trust? Under the first part, traditional view, yes. If the contract was within trustee's powers and he acted with reasonable prudence. Now, tort liability. Is the trustee personally liable to the third party? The traditional view, yes, including for torts committed by the agents. And under the modern view, no, unless the trustee was personally at fault or liable under respondent superior. And now, may trustee seek indemnification from the trust? Under the traditional view, no. If the loss resulted from the trustee's breach of duty, example, failure to insure, or the trustee was personally at fault. Next section, F, duties and liabilities of beneficiaries. Beneficiaries' duties and liabilities generally. Number 1, A, no affirmative duties, section 825. Section A, no affirmative duties, section 825. Unless a beneficiary is also a trustee or unless an obligation is imposed by provision of the trust in which she has expressly or impliedly accepted her interest, the beneficiary owes no affirmative fiduciary or other duties to the co-beneficiaries or to the trust estate. B, duties regarding breach of trust, section 826. If beneficiary does, however, owe a duty, as do third parties, to other beneficiaries not to participate in a breach of trust by the trustee and a duty not to profit by the trustee's breach, see restatement the second, section 256. Number 1, mere consent, not participation, section 827. The mere consent of a beneficiary to trustee's breach of trust, example, consenting to a proposed investment that proves to be improper, does not constitute a participation in that breach. However, there may be a fine line between mere consent and participation. A beneficiary who induces a breach of trust has been a participant in it. Number 2, liability of beneficiary, section 828. An innocent beneficiary who profits from a breach of trust but did not participate in it is liable only to the extent of the improper benefit, that is, the unjust enrichment. A beneficiary who participates in a breach is liable not only to the extent of the improper benefit, but also for the damage to the trust estate or other beneficiaries. Number 3, beneficiary's change of position, Section 829. The liability of an innocent beneficiary who profits from a breach of trust, even a good faith mistake by the trustee, is based on the theory of unjust enrichment. If, however, the beneficiary has changed her position in reasonable reliance upon, for example, an overpayment or other improper distribution by the trustee, this is generally held to preclude recovery by the trustee or other beneficiaries who may nevertheless surcharge the trustee. C. No duty to indemnify trustee, Section 830. A beneficiary has no duty to indemnify a trustee for liabilities incurred in the course of administration, even under circumstances in which the trustee is properly entitled to indemnification from the trust estate. Of course, if a beneficiary has contracted to do so, she may be held liable to the trustee. It also appears that such an obligation of indemnification may arise with respect to the beneficiary settlor of a trust created for the business purposes, and see Scott on Trust, Section 249. Number 2, remedies against beneficiaries, Section 831. Where a beneficiary has participated in or benefited from a breach of trust, the beneficiary may be held personally liable, as may the trustee, to the extent of the liabilities described above. A. Beneficiary's share impounded, Section 832. Whether the beneficiary's liability is purely as beneficiary or in her role as trustee as well as beneficiary, her beneficial interest is subject to a lien or is charged to ensure payment of that obligation. Benefits accruing to such a beneficiary are suspended and impounded until the trust estate has been restored or resulting obligations to the other beneficiaries have been paid. Next, page 230, number 1, the rationale is impounding is an application of the general equitable principle that one entitled to participate in a fraud cannot receive its benefits without first discharging any obligations to the fund. The creditors and assignees of beneficiaries, Section 833. Suppose that even before others learning of a beneficiary B's participation in or liability as trustee for a breach of trust, B assigns her beneficial interest in the trust to a bona fide purchaser for value, a BFP, or to a creditor of B attaches that interest. What are the rights and priorities of these third parties as against other beneficiaries or the trust estate? Number 1, the general rule, Section 834. The general rule is that the BFP or creditor has no better status than B herself had at the time of the assignment. The interest is subject to the charge securing B's liability to the trust and other beneficiaries for losses resulting from the breach of trust. Number 2, the rationale. The BFP doctrine, whereby a BFP cuts off existing equities, is the rule applicable to the purchase of legal titles and is generally not applied, absent a statutory basis, to the purchase of equitable interest. Therefore, a purchaser, and a fortiori in a creditor, does not cut off a prior lien on the beneficiary's interest to secure repayment of her obligations to the trust estate and other beneficiaries. Number 3, note, some courts have applied the same rule where the breach of trust occurred after an assignment of the beneficial interest on a theory of once beneficiary's interest, always beneficiary's interest. This overlooks the fact that after the assignment, the original beneficiary is no longer the beneficiary, the assignee is. Thus, the restatement position is contrary to the cases taking the position that a BFP should not suffer for losses and defalcations by B subsequent to the time of the assignment. See Restatement the Second, Section 257, and see also Scott on Trust, Sections 257.3. Now, the exam tip: although a beneficiary generally does not owe any fiduciary duties to the trust or other beneficiaries, she does owe a duty not to participate in a breach of trust. If you encounter a fact pattern in which the beneficiary has participated in a breach of trust, example by inducing the trustee to make an improper investment, she is personally liable for any loss incurred by the other beneficiary as a result of the breach, and her beneficial interest is subject to a lien or a charge for the amount of the loss incurred by the other beneficiary. But remember, mere consent does not constitute participation. Now, Section G, liability of third parties. Number 1, generally and for breach of trust. A, debts owed and acts adverse to trust, Section 835. Where a third person or third party is indebted to the trust estate, commits a tort with respect to the trust estate, or is in breach of a contractual obligation to the trustee, not the beneficiaries, has the right to maintain a suit against the third party for collection of the debt or for damages or other appropriate relief. This right of the trustee, of course, passes to the successor trustee. If the trustee fails to enforce the trustee's rights, the beneficiaries can bring suit in equity against the trustee to compel her to perform her duties. Under the modern principles, any one or more of the beneficiaries in such a situation can now maintain a suit against the third party by joining him as co-defendant with the trustee. Or if the trustee is not subject to the jurisdiction of the court, the beneficiaries can generally maintain a suit in equity directly against the third person without joining the trustee. B, breach of trust, third-party participation with trustee, Section 836. Under appropriate circumstances, a third party who participates with the trustee in commissions a breach of trust is liable to the beneficiaries, or to the obligation may run to the trust estate. The third-party liability is the result of an inference with the trust relationship. That is, with the duties owed by the trustee to the beneficiaries, and thus the cause of action primarily belongs to the beneficiaries, although the usual rule today also allows suit by the trustee, a co-trustee, or a successor trustee on behalf of the trust estate or beneficiaries. Number 1, improper transfer, Section 837. Third-party participation in a breach often involves a trustee's improper, maybe good faith, transfer of trust property to a third party. The transferee's possible liabilities in this situation are discussed in Section 841. Number 2, application of funds, Section 838. A third-party direct or indirect involvement in the trustee in a breach of trust may also take the form of the trustee's misapplication of funds paid or other property transferred into the trust by the third party. Under what circumstances is the trust party liable in such cases? A, notice, Section 839. Essentially, the third party in this situation is liable for participation in the trustee's breach of trust only if, at the time the payment or transfer was made, the third party had notice of the trustee's intent to misapply the money or other property. Next page, 232, the graph there. Approach to determining third party's liability for improper transfer of trust property. Did the transferee purchase the property for value? You have two options there, no and yes. If it's no, donee takes subject to the trust and normally has a duty to restore the property to the trust. If yes, did the purchaser know or should she have known that the transfer constitutes a breach of trust? Two options here, yes and no. If it's yes, non-VFP takes subject to the trust and normally has a duty to restore the property to the trust. If no, the BFP takes free of the trust and has no duty to restore the property to the trust. Next page, 233, B. No notice, Section 840. If the third party pays or transfers property to the trustee with no notice of an impropriety in the transaction or the trustee's intention to misapply trust funds, there is no liability. Even if the third party knows of the existence of the trust but has no notice that the trustee has wrongful intentions, the third party is not implicated in the trustee's wrongdoing. Exam tip here. Remember that direct suits by the beneficiaries against third parties who are liable to the trust in contract or torts generally are not permitted. The trustee alone can sue. The modern view, however, allows derivative actions by the beneficiaries or possible actions by a trustee ad litem against third parties if the trustee unreasonably fails to sue the third party, or perhaps if the trustee participated in the breach. Number 2, third party's acquisition of trust property, Section 841. Of course, where a trustee improperly transfers trust property, the transferee takes good title and has no liability to the trust estate or its beneficiaries, except, of course, for contractual or other obligations incurred in consideration of the transfer. The present discussion is concerned with the situation in which the transfer constitutes, for one reason or another, a breach of trust on part of the trustee. Questions then arise with respect to the rights of liabilities of the transferee. A. Donee, Section 842. In such a case, if the transferee is a donee, even in good faith or without notice, he does not take the property free of the beneficial interest and may be required to restore the property to the trust. B. Bona fide purchaser, Section 843. If, however, the transferee is a BFP, the transferee takes good title to the property free of the beneficial interest and has no duty to restore the property to the trust estate or other liability to the beneficiaries. Quote, a bona fide purchaser takes free of latent equities, unquote, and in this situation, the bona fide purchaser doctrine has generally been applied even where the trust property transferred was itself an equitable interest held by the trustee as part of the trust res. C. Purchaser not bona fide, Section 844. If the transferee is a purchaser but is not bona fide, he, like the donee, takes subject to the beneficial interest and has a duty to restore the property to the trust estate. Number 1, non-BFP, Section 845. Clearly, a purchaser who knows that the trustee is committing a breach of trust is not a bona fide purchaser. However, the mere fact that the transferee knows of the trust, that is, that the property is trust property, is not sufficient to deny him BFP status unless he knows or should know that the trustee's transfer is a breach of trust. A. Knows or should know, Section 846. The transferee is not a BFP not only if he actually knows of the breach of trust, but also if, under the circumstances, he should know of the breach of it. By reason of statute or otherwise, he is deemed to know, example, by having a duty to inquire and thereby being charged with such knowledge that a reasonable inquiry would have produced. The laws of the several states differ with respect to the circumstances under which the party is under a duty of inquiry into terms of the trust and into the circumstances surrounding the transaction when he knows or should know that he is dealing with a trustee. And that ends that whole Chapter 6. And we will pick up next week, maybe with a review of that chapter before we go on any further into another one.
So we're ready to open up for questions, Christian?
Yes, why don't we do that, yeah.
Hey, folks, if you got a question, hit *8 on your phone, and I'll see you pop up here. And we'll unmute you in order that you jumped in line, and you can go ahead and ask Christian the question. First one is our friend Dominic from Ireland. Dominic, how are you?
Hey, Matt. How are you doing?
Good. Welcome to the call.
Thanks very much. Hey, Christian.
Go ahead, Dominic. I was just getting back.
All right. Okay.
Thanks.
I'm just looking for a bit of clarification on something. It's actually in relation to a court summons. I'm correct in saying a court summons is a death title, isn't it?
Yes.
If you haven't expressed any form of trust terminology on the death summons, on the death title, what would be the best way to tackle it?
Well, that kind of brings into what we were talking about on one of the past recent calls here, where we were going over that Lewin book on the law of trust, the practical treatise on the law of trust, where it was talking about on page 1, it talked about the subpoena.
Yeah.
And really the subpoena was for the real man, and the summons was for the corporation or the fiction. So what they're doing now is you got a summons, right? You didn't get a
Yeah.
So what they're doing is there's summons and then the corporation, and whoever shows up and is going to represent the corporation. So when you come in on the summons as a real live man, that real live man is now deemed to be the trustee for the trust there.
Okay, so the very second he enters that courtroom, the real man is assumed as the trustee straight away.
Yeah, because the summoning in the corporation, whoever's going to represent the corporation is going to be the one as the trustee for the trust there.
Okay. Okay, fantastic. So when you enter into the courtroom, you're the trustee. The beneficiary is obviously the plaintiff. The
Yes.
plaintiff beneficiary is obviously the plaintiff. Yes. Okay.
Hmm.
Okay. So the best thing to do is to.
Oh wait! I'm almost finished. Now you can probably throw a monkey wrench in that because you're assumed to be the trustee. So some of the cases that we put in there, we stopped the foreclosure right on the sale block, was that the court is construing that you're the trustee. But when we came in and made a claim, which was just the NOI, that we were not the trustee, but we were the beneficiaries, now we got a conflict of information here.
Okay.
So if you can prove, following up your NOI, that you're the beneficiary, if you can prove with the material facts with the SOI to support your NOI, now that's got to stand because you got the proof that you're not, say, the trustee. So you need an NOI and an SOI to say that I am the beneficiary.
No, these are just basically notices, like a notice of interest and a statement of interest. The UCCs.
Yeah, but see, you need to create a trust as grantor, and then create that trust based off this summons, this case.
As there is.
They can spell out who the parties are, because if you're the grantor, you got the right to spell the parties out.
Gotcha.
Correct their misconstruement.
Okay, correct the misconstruement. So you would basically send in the original summons, obviously, as the debt title, or sorry, as the asset title, correct?
Well, treating a trust res, yes, as the case.
Okay, so you'd send them off that, an NOI and an SOI as well, into the court.
Create the records that you are the grantor and you're creating a trust, and then you got the right to correct the misconstruement that they're construing you to be the trustee, but now you've got the evidence in being the grantor is setting up who the beneficiary is, and you're the beneficiary.
Now, the summons is set up for a public arena. This will be a private trust, one that we'll be creating.
Yeah, because there's nothing there in their documentation that there is a trust. So everything about a trust is secret, it's private, and it needs to be disclosed only in chambers.
Okay. I think you mentioned something in last night's call. I know you touched off this briefly last night as well. I didn't get a chance to fully listen to it yet. But I think you mentioned something about not doing a UCC or a non-UCC before transfer or something. Did you mention something like that last night?
Yeah, we talked a little about that because really the trust was not, I think it was Carlos that mentioned something about it, and you really can't do the UCCs, or I forget exactly what he said about whether he was making a claim or something. But anyway, the trust had not formed yet until you transferred the property. And I remember what it was. It was a mortgage. He was filing the UCC on a mortgage foreclosure or the closing prior to going to the closing. there was no trust formed until closing because the trust res didn't transfer until closing. So therefore, he couldn't come back 3 days, say prior, 72 hours, and do a UCC filing and treat it as a trust because the trust wasn't formed yet. He had to do it after the trust res, and the trust res formed the trust, and then file the UCCs. And we were talking specifically as a trust receipt record of a payment.
Christian, I thought you told me that. I'm sorry, Dominic, I jumped in on top of you there, but I just had a quick question about the trust creation. Didn't you tell me that the 1003 mortgage application created the trust?
Yeah, I think I did, yeah. But we were talking about what they can see was really the note, and the note in that Nevada case, the judge was saying that the signer of the note, that was the grantor. And if we're treating the note as the trust res property, then that's when the trust would be formed.
Yeah, that totally makes sense if you look at it from that standpoint. I just wanted to get clarification on the 1003 mortgage application because you're...
If we were treating the application as the formation of the trust, then that would be a different situation then.
Okay. Go ahead, Dominic. Thanks.
All right, no problem, Matt. Okay. All right, okay, so that's where Carlos was coming last night because that sort of threw me off because I was wondering, okay, you know, because in order to claim the trust, you're going to have to do UCC1, like.
Yeah, to prove
the
trust, yes, but under that particular situation, the trust hadn't formed yet because the note we were talking about was being the res, and it hadn't been referred to the trustee yet, so no trust existed. So he couldn't, prior to that trust formation, come back in and claim that there was a trust.
Yes, I understand. When now a trust isn't correctly formed either until delivery is effected, isn't that correct?
Say that again.
There has to be delivery of the trust res before a trust can be formed.
One of the four methods of trust formation, and delivery is one. Could be others.
Could be others as well. Okay, I got you. All right, so just get my head around this. The summons is the debt title. You basically do an NOI and claim it as an asset title. Do your NOI, which is your transfer of the parties, or you're assigning the parties, or the correct parties, that is. And you're sending this paperwork off to the court under private trust, with I presume followed by an indenture as well, the usual, Christian.
Right. Some kind of oral.
Okay. Some sort of oral statement or written statement of who the parties are, of what the instructions are to do. That's pretty much it, isn't it? Yeah. I just wanted to go through that because I was just uncertain.
Well, that's one way of playing it. You could play it another way. You could agree that you are the trustee.
Yeah, I was going to ask you about that as well, yeah.
You could agree you are the trustee, and you could agree that you didn't make a payment. And then we can go into chambers and I can tell you the reason why I legally can do that, not make a payment. Which is, this is a discretionary trust, and it's per the discretion of the trustee whether or not he makes a payment or not, because the beneficiaries are bankrupt. If I made a payment to the beneficiaries, then the creditors are going to seize the beneficiary's assets, so I can't do that. Otherwise, I'd be forced into breaching the trust. So then, by the way, what I'll do is I'll make the beneficiary solvent, pay all their debts, release up the funds, and then that'll so I can make the beneficiary solvent.
Okay. So how would you effect payment as a trustee in private chambers? Just do the same thing again?
Yeah, with the special deposit, yeah.
Special deposit, okay. Excuse me. The asset title that I'd be doing this on, I can also claim that as special deposit, can't I?
Yes.
Fantastic. Actually, yeah, you mentioned that about the trustee before as well in relation to the master trust and how to function correctly as a trustee. Excuse me, Christian. that you could actually perfect that role and go around and make payments as a trustee under trust.
Yes. Yes.
Yeah, you mentioned that the last day as well. I find that very interesting too. That
where
side of things.
I think there's why we're not successful at that is because number one, we haven't claimed that there was a trust, or we are claiming that there is a trust. Let's put it that way, but we're not proving that that trust exists. And if we don't prove that that trust exists, and we don't prove that we are the trustee, then how can we have the authority to make a payment then?
Correct. Yeah. Makes sense.
So we're going to have to go back and prove that a SETI K trust exists in order to have access to it, and then we're going to have to prove that we are one of the parties as, say, trustee that has the right to make the payment on that trust.
Mm-hmm.
And then when you do that, then you can make the payment, and the payment should be valid.
Well, the proving the trust should be easy enough if you could find the right wording in whatever constitution you're using or whatever.
Yes, but I think it's kind of easy to prove because all you have to do is create the records, and they don't have any records to say otherwise.
Yeah, of course.
How are they going to prove that their birth certificate is not a trust when you got the records to prove that it is a trust?
Yeah, that's very true. Makes perfect sense. Christian, thanks very much. If I have any more follow-ups, what I can do is I can pop on later if that's okay.
All right. Yeah.
Thanks, Christian. Thank you. Thanks, Matt.
Thanks, Dominic. Great to hear your voice again.
You too, sir. You too. Thank you.
We got anybody else who's got a question for Christian? Go ahead and hit right on your phone, folks. Got about 30 callers on tonight. It is now 9 o'clock Central Time. Here we go. Caller just popped up here. Let me go ahead and unmute him. North New Jersey.
Yeah, this is Bill. How you doing?
Hey, Bill. Welcome to the call.
Thanks. We're just talking about establishing the trust, and Matt raised the question of using the application for the mortgage as formation of the trust as well. Is that an option? Or because last night in the call we were talking about just waiting 72 hours after the note was generated.
Yeah, you could use the application as the formation of the trust and also the power of attorney.
So then, in that case, Carlos from California could have created the trust prior to signing the mortgage note.
Okay, but now he's talking about the note, and the note didn't transfer to the trustee or to till the closing. So we still got the same situation.
But I mean, wouldn't it, if we use the application as the res to form the trust, then that wouldn't really matter, would it?
Right. You could treat it as two separate trusts. You could treat it as one trust, but then it would be dependent upon, how you wanted to treat what trust res was and when did it transfer. Because the application was, months before, say, the closing. Where at closing, you couldn't have done it prior to the filings prior to closing. Then, if you're going to treat trust res being the note.
Right, and to your knowledge, if we were to take the application as the trust res forming the trust, and we were to come in as
couldn't use them simultaneously being both. You'd have to choose one or the other.
Okay. So we couldn't put one on top of the other.
Unless you treat them separate trusts.
What I'm thinking is that if we did the application first, that would give us we could make ourselves trustee for the closing of the property and giving ourselves.
Yeah, but it really, what we're trying to do is we've got this debtor-creditor thinking again that prior to the escrow closing, we should go and we should file this UCC-1 thing. But that is based on what we've learned prior under debtor-creditor. It really makes no difference whether we're going to file a UCC-1 afterwards. That's just going to that's going to be just as good because really we're talking about trust and we're not talking about debtor-creditor and using this UCC as a filing for a lien or a status in the claim there, the note. We're talking about it being perfecting the transfer of the property in the formation of the trust.
Exactly. Right. No, I wasn't thinking debtor-creditor. I was just trying to.
Yeah, but I know we have this debtor-creditor thing because I know exactly where you're coming from there because, we should have filed a UCC-1. That would have claimed our note, which would have effectively made it ours. But that's not trust. We want to get a trust receipt being the filing on the UCC, that being the receipt, and that being the record of a payment. And that can't happen until after the trust after the trust was formed. Where before, if we're talking about a UCC being under debtor-creditor, it didn't make any difference. We could have done it before and claimed it. But claimed what? We weren't claiming trust.
So then it wouldn't be to our advantage to use the application as trust res.
It could if you wanted to go by the grounds that the funds were being created someplace and before closing, before you went in there and signed, and what created the funds, it was your signature on the application. So if you wanted to go back and claim those funds, then it would be. You'd go back after and treat it as the application being the start of the trust. Now, if you want to claim the note, so you have like two instruments here for an equal amount of value that are one is operating solely in the private, which would be the application, the formation of these funds, but then the one that they see in the public is going to be the note. And they're the same amounts. Because that application created the funds that was transferred to the escrow agent to give you the amount of money to make the payment for the house at closing, although you hadn't even signed the note yet.
Exactly.
Yeah. So you have two equal amounts, and you could treat them as separate trusts or two separate claims. It just depends on how you want to play it, whether you want to go after both of them or just the amount of the note that shows up in the public.
Right. So now, if one is in the public and we want to stay private, then isn't that to our advantage to stay as private as we can?
Well, I can't change the fact that the note's in the public.
True that.
But I can treat the claiming and the collecting of everything as being held in the private, and I could go after both amounts.
Right. So as you say, it's just a strategy approach. I mean, we have.
Yeah. Right. It just depends upon your knowledge, how you see it, and how you want to attack it.
Right. Right. Okay. But I thought it was just interesting that you brought that up now because it may have some bearing on our strategy for.
But just when we started out, say 2 months ago, we're trying to keep it a little more simpler and keep it on one single strand of thought. But now we actually have more multiple things running, and people probably couldn't handle that type of thought back then, but now they can.
Well, we're playing three-dimensional chess now.
Yes. And we were only teaching one dimension at a time.
That's right. Okay. Well, that's and then interestingly, also this evening, reading about the rights and duties of or rights of the beneficiaries against the trustee. That's a strategy position as well, because sometimes depending upon where we are, it's to our advantage to be beneficiary.
Right.
Other times it's to our advantage to be trustee.
Right.
So it's like knowing which one to choose at which time based upon what we're trying to do.
Yes. But like I was pointing out to Dominic, it makes no difference which position you choose. You're in a win-win situation. It just depends upon your knowledge and your understanding.
Right, exactly. Oh, I just had a comment on that. That's all I have right now. Thank you.
Okay. That's a good question.
Thanks.
All right. Thank you for your questions. Next caller is Texas Sailor Boy.
Oh, thank you. Thank you very much. Hold on.
You've been unmuted. Texas Sailor Boy, go ahead.
Oh, Christian, that was fabulous.
How you doing, Dave? Excuse me.
All right, Rick. Christian. Hey,
I heard you forgot your name. It's been so long since I talked to you.
Oh my gosh, you have too many shows going on now.
Oh.
You're all over the place. Well, I want to go back to what you were reading on page 231 on the first paragraph under generally and breach of trust.
231?
And yeah, page 231 under liabilities of third parties. And the last sentence of that first paragraph, in parentheses, it says, if the trustee is not subject to the jurisdiction of the court. And I was wondering if you could give us an example of a trustee that was not subject to the jurisdiction of the court.
Yes, if my law form was a specific law form that specified that it's as a non-resident alien, like on the W-8 Ben on page 7, that was doing a barter exchange or a transaction, that he was not connected with a business or trade in the United States, then he's not in the jurisdiction.
Agreed. However, do you think the people that wrote this book had something like that in mind? Since this is a statutory trust book, I was wondering what
written here is to keep you operating under statutory public policy and law so that they can be construed any way that they want to for the speed of commerce, which is debtor-creditor.
Okay, so in a real world, let's say my sister's been listening to your program, but she just has a very rudimentary understanding. I mean, it's really, really basic. What would prevent her from making me a trustee in her situation?
Well, nothing would prevent her from making you a trustee, but everything hinges upon you whether you wanted to accept being a trustee.
All right, so if I accepted that and I went in there at their hearing, at their first little hearing where they determine whether or not they're going to allow the courts to have the bank to have their foreclosure sale, and I start raising the question, wait a minute, I've got a fiduciary duty here as the trustee to protect the interest of the trust. And right now, we haven't seen any evidence that these banks have a secured interest in the res of the trust.
Okay, but that's a conclusory pleading without any SOIs to back it up. Where were you in the hearing when it was adjudicated otherwise? And now, unless you made a claim within the time, then you're cut off, and you're not a bona fide purchaser with any kind of rights or standing.
Now, what if we had asked previously, like 3 months ago, for a payoff statement, and they gave it, and we accepted that payoff statement with the condition that we're putting up the money, but there's one catch. You got to come down and get the money and bring the note with you. and you've got a certain period of time to do that. And then they defaulted on that, and that default was certified by a third-party escrow agent, officer, quote, unquote, of the state, like a notary.
Mm-hmm.
And now, basically, in commerce, they're in default.
Right.
And then we recorded that evidence, that information into the public record, not the court case. The court hadn't come up yet. We just recorded it as public information in the public record.
What did you record?
We recorded the certified default and all the supporting documents with it.
What exactly was the certified default?
That on certain days, the escrow agent notified the company that she had in her possession legal tender funds in the amount of what the payoff was, plus extra for costs and fees, and that they had 15 days to come get the money.
Notary certificate of dishonor, is that what you're talking about?
Yes.
Okay, did you record that notary certificate along with the documentation and wording that you just said into the county?
Yes.
Okay, you just waived it by making it public.
And when you say making it public, wasn't public in the court case, it was just in the public record.
But a county recorder is a public entity, and anything you put in the county recorder makes it public, and then you thereby waive it.
And when you say waive it, what are you saying? You're allowing them to sweep it under
voluntarily disclosed it into the public, thereby nullifying your confidential commercial information, your trade secret, your private administrative remedy that you're running in the private.
Well, other than that,
what you should do is record a notice. Just record a notice that an RA number exists, and then all the details is held in the public or held in the private.
How do they overcome the default? Just because you recorded in the public, it's no good?
Well, they already have overcome the default because you didn't step forth with the default and do anything with the default. Because really the default, the certification by the notary, is your win on a silver platter if you know what to do with it by bringing it forward into another case, say an independent action now, since maybe this one's closed, using that as the unclean hands doctrine and coming in and putting an estoppel on this thing and putting a permanent or a preliminary injunction or a temporary restraining order in this, and then bringing forth the information, but only in the private, in an in-camera hearing to prove that you already made the payment, but treating it as trust.
So sounds like to me what you're saying is, because it's recorded in the public, it's not evidence.
Well, it's evidence that's been waived as CCI information. It's now public information, and if you bring that into court, they could come back in and say, well, they won't hear it. They'll ignore it.
Well, in this situation, it's a hearing in the state that she's in. The
all the states report to Federal Rules of Evidence 501, which basically drags you back down in your individual state. But in Florida here, it comes back down to 90.501 through 90.510, but in particular 90.506 and .507. 506 is with respect to privileged matter, which is your CCI, and then 506 is waiving it by voluntarily disclosing it. So by putting the details into the public by the county recorder, you have waived your private administrative remedy. People don't understand that.
I don't understand why, if truth is in commerce,
yeah, but
and truth is on
your common law, which is an affidavit stands as truth, but that's common law, which is held in trust. It isn't even in the public anymore. The only place that's in public is in chambers. But you can't claim that right until you get into chambers. What it all boils down to, it's like we're going over to France and we're telling these French people how to run their government, their country, and we're telling them they got to run their country in France according to American law. And they tell you, get out of here. It's the same thing. France is the democracy, the United States. And we in America in the Republic, keep going over to their venue, telling them how to run their country. And they tell us, get out of here. Our rules don't work that way. They're going by a different rule system, and you got to know and understand their rule system to get anywhere in their country. And what we've done when we do that is we have taken our American rights and our American laws, and we've gone over into this foreign country, the United States, and we're telling them how to operate. And what we've done is we have commingled the trust, and we ourselves have breached the trust by telling them they have to operate a certain way. They're separate entities. They're a democracy. They're the United States. They have nothing to do with America. We're in a different...
Okay, I got it. Now, to bring it back around to another direction, let's say it's a different case, and you do exactly what you say, keep it all private, and just put notices in the public record that the evidence exists.
Yeah, I would rescind that publication if I could, and do another refiling of just a notice now. And since that more current notice will take precedence over top of that old one, then I would bring in that notice. That would be the mirror from the private into the public. And then I would bring in that administrative remedy. But I would bring it in under a protective order and under an in-camera hearing.
Now, do you still feel strongly about making the judge the trustee, or why wouldn't you want to be the trustee yourself?
You can. That's what I'm trying to point out now. It's like now we've got the understanding and a little more in-depth knowledge that why would you want to change something that's already in place? We already got a trust. We're already the trustee. The only thing we really have to do is prove that we got a trust in order to substantiate the claim that we got a trust, and then say that we are a trustee, and then we've got the right to make the payment. But then keep it all private.
Well, I agree. And tonight was the first night I heard that trustee and beneficiary could be one and the same.
No, I didn't say the trustee and the beneficiary can be one and the same.
I thought I heard you say that in the reading here. It says on page 228, at the bottom of the page, beneficiary's duties generally, unless a beneficiary is also a trustee.
Where's that at? 228 what?
228 1A. At the bottom of the page, underneath that chart, well, it's not a chart, but...
Yeah, the beneficiary owes no affirmative fiduciary or other duties to the co-beneficiaries or to the trustee?
Well, read the beginning of the paragraph.
Read where again?
Unless, the very beginning of that paragraph.
Or unless the beneficiary is also a trustee, or unless the obligation is imposed by a provision of the trust.
That implies that a beneficiary could be the trustee, doesn't it?
Yeah, but not simultaneously being the beneficiary, or the grantor can't be simultaneously trustee and beneficiary at the same time. Now he's all three parties.
Well, in that situation, I can understand. But the language here is, unless a beneficiary is also a trustee, which would imply that there might be more than one trustee.
All right.
I'm sorry, did you say no?
No, he can be a co-trustee.
Okay, a beneficiary can be a co-trustee. So,
but it would have to be spelled out in the indenture what specifically keeps them separate. It's going to have to.
Yeah, have you ever seen a trustee appointment document?
A trustee document?
there should be some common document that you use as an appointment for trusteeship.
Yeah, if you go to Weiss's Concise Handbook on Trust, you'll see some examples in there.
Could you repeat the name of that again?
Carlton A. Weiss.
Oh, Weiss.
Handbook
Okay.
on Trust.
Gotcha. All right. Well, let somebody else ask some questions. I wanted to get that cleared up, so I appreciate it. And if nobody else has any, I'll come back in later.
All right, let's move on to the next one. Northeast California. You've been unmuted. Go ahead with your question.
Chris?
Yeah.
Hey, Christian. Jim Macklin up in Northern California. How are you?
Okay. How are you doing?
Yeah. Quick question. I've been listening lately, but haven't been able to get some bad feedback. Can you guys hear me?
You're breaking up there a little bit.
Can you hear me now?
Yes, try again, yeah.
Okay, that's much better. Sorry about that. I've been listening and just haven't had questions for the last month or two, but I do have a couple of quick questions. With respect to a mortgage situation and going back after the note, do you think that there's any benefit to claiming the res of the trust as being the signature on the note as opposed to the actual note?
Well, that is the res, really.
Okay, so you could say either or, but
yeah, because the signature, whatever the proceeds my signature generates, that's off of the that's really off of the trust res.
Right. Okay, and then in a motion for, say you're going to take this back into court because you've got to get into chambers through through some sort of a motion to the court, you could do any sort of even a claim for breach of trust or something along those lines, and then do your CCI request or motion.
Yeah, the CCI is the claim, or excuse me, the motion would be the claim that there was a cause of action, a breach of trust. That's the NOI. And then your CCI, which would be your SOI, the material fact to support that breach. And that's
okay. That clears something up. The SOI is actually the motion for the in camera.
No. That's actually the motion is just the notice, the NOI.
Oh, motion is notice. Okay, and what's the SOI?
The material fact to substantiate the claim, which is the notice. The claim is the notice, the NOI. That would be the motion. And then the details of the facts to back up that, say, breach of trust. The facts, that's the SOI. That's the CCI information.
Right, and that's your stack of documents that have been recorded.
Yes, right.
Gotcha. And then one last thing. On the public filing, I know that you have two filings, both the UCC one and then as well as one with the recording. Is there a particular document styling that you would use? What is it that you're claiming to record at the public recorders? Because they hate me down there.
All right. On my website, movingtitles.com, and go to the content page where it lists the documents. Under the documents section, you'll see an example of a county notice and a UCC1 verbiage to put on.
Okay, that's been recently in the last month?
Yes.
Okay, that explains that. Yeah, I'm in California.
It's only like 3 lines. On the one in the county, it's just that you claim it, and it's only like 3 lines long. And then on the 3 in the county, you change one thing from claiming that we would use on the 1. You use the word transfer, and you use that. The 3 lines, basically the same thing, except one word change, basically. And you use that on the 3 in the county.
Okay, thanks. You know, it's interesting. For about the last 30 days, I've been reading a bunch of California case law, actually trying to find how the court is going to get around this, and it's really amazing because all the language that's being used in the case law points to trust in every capacity. They just
haven't been seeing it as trust.
That's right. And all of a sudden you recognize that you didn't make a claim against a trustee, which is the only claim that can be made. in equity. And one little tip too, if you're trying to challenge, let's say something's already gone to trustee sale, if you don't challenge a BFP, a bona fide purchaser, then it's admitted. But if you challenge a bona fide purchaser, then that challenge can be heard. So, But yeah, the whole thing's in trust. Everything they point to is beneficiary trustee. So, hats off. It kind of comes together after you really get through this. Okay,
yeah.
Thanks, Christian. You
Once we
answered my question.
exposure to trust, and now we start seeing things in trust eyes, we all can see it. It's all been trust all along.
Yeah, it is amazing how it just kind of puzzle pieces together, and you never knew it was there. All right, thanks, Christian. Appreciate it.
All right.
All right, next caller, Christian 90. You've been unmuted. Go ahead.
Hey, Christian. This is Christian Goodell in Southern California. How are you?
All right. Good.
Good. Question for you on the recording of private information that you were just talking about with the other gentleman a couple of calls ago, or a couple of people ago. If we are filing a affidavit of obligation, commercial lien, are we not required to file that affidavit into the public record? And does that not divulge some private confidential information and cause it to be then waived?
Well, if you're talking about a lien is required to be recorded in the public.
Okay. That was my understanding.
But isn't a lien debtor-creditor under
it
union?
Is.
Talking
It
about
is.
a negotiable instrument, which is not private really, because it's not listed as being non-negotiable, because non-negotiable is private. So here, all this confusion, what we've been thinking we've been doing is not so, because things don't add up. If it is trust, it's non-negotiable. All our instruments are non-negotiable instruments. That's private. If you're doing debtor-creditor, which is public, you're doing negotiable instruments. This lien is a negotiable instrument. You're doing debtor-creditor.
Well, let me back up and tell you where we are, because I'm not at all new to the debtor-creditor information and somewhat newer to the trust information. And my team and I have been listening to your calls and trying to get in the mindset of getting out of the debtor-creditor. And I think you're absolutely right on that. But let me get your opinion on this. I have a friend that's going to trustee sale on Monday.
Mm-hmm.
And we've done a private commercial affidavit process, of quite a strong one, I believe, and we have the notaries.
Have a certificate of dishonor, like a debt validation. They didn't respond.
Yes, it's a perfected claim in the private at this point.
Okay, so that certificate, that's what you're going after, because like I was telling the other fellow there, that certificate is the confirmation by the notary that they have unclean hands. And under the unclean hands doctrine, a court of equity, you can't come into a court of equity being on foreclosing on a mortgage foreclosure with unclean hands and ask equity to do something for you when you yourself aren't doing it.
Right.
So that certificate is a valuable piece of document that you can use to create a temporary restraining order or preliminary injunction and freeze that sale under the doctrine of unclean hands, because that's the estoppel, because they can't do a mortgage foreclosure, sell the property, or have anything to do with it because they have unclean hands. Look at the definition of equity. When it says you can't come into equity, it says that, and ask equity to do something for you according to equity when you yourself aren't doing equity.
Makes sense. What would be the correct process to stop the trustee sale most effectively, and is there a way to record that?
Go to the law library and do some quick research on a temporary restraining order, preliminary injunction, and make sure you got the necessary elements necessary to enforce a TRO action.
Okay.
Because you're being irreparably harmed, and there's no adequate remedy at law.
Is an NOI adequate remedy? Is it going to, as Winston Shroud says, going to basically cause them to stop their procedure for 21 days?
Well, what's going to stop the procedure for 21 days?
An NOI.
Yeah, but I wouldn't count on the NOI pulling the sale off, although it did with us on that once. But I would come in with something more powerful now. I would come in with the NOI and the SOI. See, what we did was we came in and the court was construing us to be trustee, but we came in with the information, the claim that we were the beneficiary. Now we got a conflict of interest. And we made a claim also that the court couldn't sell the property free and cleared because they were not a bona fide purchaser. We'd given them hereby notice by this documentation we put into the court. But that only stopped it for another 30 days because they waited for us to bring in the SOIs, and if you don't bring in the SOI or serve it simultaneously with the NOI, then within 30 days it's going to time out. And they'll reset the sale again. But if you come in with a preliminary injunction based on the unclean hands doctrine, now you got something colorable that they can see on the public side that'll jam up this court proceeding, and you can do it colorably.
Okay.
We never really realized what we had with the notary certificate. Once he generated the certificate, that was a doctrine of unclean hands certification. The notary certified that entity has unclean hands. And we never realized under a court of equity, getting that in chambers, that gets that kicked right out of court. And then you can ask for, with prejudice, judgment against them that they don't come back in and get you again.
Okay, I appreciate the insights.
That's just solely litigation stuff. That ain't even talking about trust.
My greatest weakness is the public court system in this whole process. Can you briefly describe how one would get what would we show? Would it just be the notary certificate of dishonor and none of the private information? And how will we get that into the judge in chambers?
First, you need to go to a law library and look up the cause of action, temporary restraining order, preliminary injunction.
Got that.
It is going to tell you everything that you need. Let's say there's 4 elements necessary to get a temporary restraining order. If you've got those 4 elements, like it says, and whatever it is according to your state, that judge will grant you a temporary restraining order. That's where most people fall down because they don't have the 4 necessary elements or the 3 necessary elements necessary for the judge to even grant it. If you do it right, you'll get the temporary restraining order. Once you got that, you got everything jammed up. Now you can come in with a cause of action saying that, come in with the unclean hands doctrine cause of action. While you're at the law library, look up that cause of action, unclean hands doctrine.
Yeah, I will. And I'm familiar with it. I guess my question is, does this have to go into an in-camera hearing in some way? And can you briefly give me an idea of how?
No, not the unclean hands doctrine, because that's a colorable cause of action. That's what I'm saying. All strictly litigation stuff on the public side. We're not even talking about any in-chamber stuff here. We're not talking about trust or anything. We're just doing straight litigation here.
Okay. And it's just the notary certificate of dishonor that I'm showing, though, because everything else would waive the rest of the process. Right?
That notary certificate was the certification that certified that bank has unclean hands.
Okay.
Now they can't ask equity to foreclose upon you because they are not doing what is required of equity of them.
Awesome. I'll open up to others in a second. Now, to bring back around to my original question, the bank has basically given us a large right. If I proceed with that in some fashion, is that screwing up my remedy in trust law?
No, you can have simultaneous processes running at the same time.
Okay. But if I disclose the private information of that.
Yeah, well, you want to make sure you don't do that. but you're using the certificate in another way.
So would it just be the certificate, or would I?
The certificate is the certification of unclean hands on this.
I understand. I mean, I'm talking about with the lien now. If we file a commercial lien,
I wouldn't. That's something. That's a different process. That lien, I would start talking about it as a trust, and then I would bring it in under trust, and that's when we're talking about the in-chamber stuff.
So you wouldn't file a commercial lien?
Well, under trust, there's no lien. It's just a debt title with an asset title. Because a lien has an amount. If it has an amount, then it has a value, and that's public. Under trust, we're talking about res. There is no value for res. It's just a thing. It's chattel, real and personal.
Yeah, to be clear, the lien that I'm talking about is for the bank's violation of our private judgment, not regarding the property. I'm not talking about commercial lien. I'm not talking about.
Under the unclean hands doctrine, you can go back in and claim treble damages for the value of the property because they've violated the unclean hands doctrine. You can claim damages. Now you can come into compensatory and punitive damages. You can come in with a $5 million claim, as well as 3 times the value of the house. That's just all strictly litigation. Once you got the unclean hands doctrine, you got them. You got more power just with that alone if you just knew how to bring it into court under straight litigation. With the mood of the courts today and what's going on with the mortgages and everything, if you do that right, you're going to walk out of there with 3 times damages.
Would you bring it into county or federal?
I'll bring it in state.
Yeah, it's got county court here.
But the affirmative defense of unclean hands is adequate to service a motion to strike by a bank because the notary certificate of protest is the prima facie evidence or the material fact of the unclean hands. And it presents evidences of questions of law and fact which need to be heard in a court. This mortgage foreclosure is an equitable proceeding where, quote, the court in its discretion may refuse to grant foreclosure of mortgage for equitable reasons, unquote. That's a direct quote out of a court case. So if the plaintiff initially failed to act in good faith, in other words, they didn't respond to your debt validation, or deal fairly, plaintiff comes into court with unclean hands, and as a result of the specific act and the omission, and as a matter of equity, the court should refuse to foreclose.
Which case setting is that, Christian?
I don't remember where it came out of, but I was quoting out something. I didn't write it down. I think that comes out of the unclean hands doctrine.
Okay.
So a motion for summary judgment or foreclosure with unclean hands based on a notary certificate is the CCI. That's where you want to, get it thrown out of court according to the unclean hands doctrine. That created an estoppel for them for foreclosing. You just have to bring it in as one.
Okay. All right. Thank you very much. I appreciate that.
All right. Thank you for the questions. Next caller, Connecticut. You've been unmuted. Go ahead.
Hello, Chris. This is Ben in Connecticut. How are you?
Yeah, Christian,
I'm sorry. Christian, I have a question. I'm relatively new to this arena, coming from, like you always say, debtor and creditor.
We all on that, so don't feel bad.
Okay. I'm in a little pickle here. I did an OID last year. I actually got the recoupment, and I've been doing conditionally accepting and doing notary presentments. I'm actually on my final leg as far as getting a certificate of dishonor from the agent, but nonetheless, I've been recently attacked by CID coming to my house, and I have a summons for next week, and I didn't know what would be the best possible approach to this, answering the summons and dealing with this and getting this whole matter discharged.
Well, we go back to like October of last year, starting then. On the website, movingtitles.com, there's all the audio download links from that beginning in October all the way till forward now. There's a lot up there. I don't know how many hours worth of audios is there, but there's quite a lot. And that's just to get you up to speed into the trust realm to where I'd even say you even have enough information to go ahead and move forward under trust.
Okay. Unfortunately, I'll do my best to try to get up to speed, but I don't know if it will be enough of time to get in terms of paperwork moving and.
Yeah, probably not. That's the thing. You're kind of behind the gun on time.
I have a game plan in terms of how I was going to approach it from the debtor-creditor side, but I don't. Based off of what I'm learning now from
Firm believer in debtor-creditor stuff. The except for value, return for value works, but only works limited under, say, 10% of the time. But that just works for any kind of tool we've been using, basically. But I see trust as being the ultimate remedy for I don't want to say put a guarantee, but I think we can get 100% remedy on this once we get this trust stuff down.
Right. And that's my thinking too. In terms of getting a final on this, because just like you had said on the past calls, I heard you before. Basically, everything that we do is a hit or miss out, in the debtor-creditor world, and there's no rhyme or reason in terms of why people's acceptance for value works and others don't. Why people do an OID and get the return and others don't.
Well, there is the answer is really in trust, and it was under discretionary trust per the discretion of the trustee, being, say, Geithner or his assignees, where he had the ability to flip a coin who got the 10% success rate.
Right. I definitely believe that, definitely. I actually have a UCC, but I have, the way I did my UCC, it's not a notice of a lien. It's actually saying that it is a lien. Any thoughts on that?
Well, I would, just like the fellow was on the call a little bit earlier, was talking about the IRS thing that he had there. It was that when you start treating the offer that they're sending to you as you're the trustee, for example, and that offer is really an offer for debtor-creditor, I'm not going to accept that offer as debtor-creditor. I'm going to turn it into a trust and return it back to them as a special deposit because they misconstrued me to be, say, the trustee. They're actually the trustees, and I'll be able to prove that. And then I've returned it back to them as a payment, and everything is really merged by titles, and it makes the payment, and that trust terminates.
Yeah, I hear what you're saying. I have no clue of even how to accomplish that. But one thing I did notice that kind of back up what you just said. Of course, when the IRS gets involved, they like to lien up everything, so they put a lien on my property. And I noticed that when I actually saw the lien, I'm showing on the title as the grantor, and they are showing as the trustee on the lien itself. It's showing United States of America, and then it says IRS as the trustee.
Okay. All right. Claim that was your trust, and then that's the proof. That's exculpatory evidence on their part that they are the trustee then.
Yeah, it actually says that they're the trustee. And I was kind of scratching my head. I'm like, that's different.
If you're the grantor, you got the right to say, well, I'm, say, the beneficiary. Then you can make a claim against the trustee that it breached because he didn't make a disbursement to the beneficiary.
Yeah, I was thinking that too, but it's like, well, ignorance is bliss.
Review the SNEP versus U.S. case. That's up on the website also, movingtitles.com website. Go into the documents section there under the cases, and you'll see the SNEP case in there.
Oh, okay. I got the cell phone number off of your website. What's the actual name on TalkShoe for this call?
I don't know, what do we call this call now? I don't remember.
Well, it's the Free
TV?
American.
I don't know.
What exactly are you looking for?
On TalkShoe you can download, the archive. So I was going to download, this calls for me to.
Are you a member of the Yahoo group, the Free Americans?
I think I am. I'm coming by way of Creditors in Commerce, and we have links on our website to other groups. So.
Well, the reason I ask is every Wednesday I send out an email reminder to anybody who's in the Free Americans, and in that email reminder, there's a link right out to the Free Americans page that has all of the downloads available.
Oh, okay.
Just by clicking on that link. It's at the bottom of the message.
Oh, okay. I'll go to Free Americans on the Yahoo group and join that, and then get up to speed. But you said if I review on your website that I forgot, I didn't even write it down.
U.S. versus SNP.
Yeah, U.S. versus SNP.
U.S. I forget.
That'll give you some clues in terms of how I can at least remove the lien from my property, I guess.
Yeah, because the U.S. was CIA, and SNP worked for the CIA for 15 years, signed 2 contracts for employment, and then he quit and violated the contracts. But they didn't sue him under contract tort law. They came after him under trust when they had 2 signed breaches of contract. Why did they come after him under trust? They claimed that they were the beneficiaries, and he went and published a book without their authorization, and then they claimed as beneficiaries the proceeds from the book.
Just like you said, everything is trust, that's why.
Yes, right. So as a beneficiary, come back at the trustee, because SNP was the trustee, the U.S. CIA was claiming they were the beneficiary, and they should have made a disbursement, the trustee, SNP, to the beneficiaries, the CIA. But he didn't. He kept the money. They claimed and won and got the money.
Wow.
When they had 2 signed breaches of contract. They didn't come at him under contract tort law. They came at him under trust. And it went all the way up to the Supreme Court, and they won.
Wow. When I saw that, that's why it kind of resonated with me when I actually found out about, your discoveries. And when I saw that, them as putting me as the grantor and them as the trustee, I'm like, why would they do that? It just didn't make any sense. But it makes sense now because it's a trust. They formed a trust when they actually gave me a notice that they were going to put a lien. I went silent. My silence was acquiescence of agreement of the trust being created, and then they just went forward with it.
Yes.
Wow. Thank you very much. I appreciate it. Thank you so much, Christian.
Okay. Welcome to New Trust Technology.
Thank you.
I'll get one other caller with a question here. Repeat caller, North New Jersey.
Hello.
Go ahead. You've been unmuted.
Hello.
Hello.
Yeah. This is Bill again from Jersey. Just a quick question with respect to this prior caller with the IRS.
Mm-hmm.
The suggestion was that he would establish a trust, claim he's a grantor, making the IRS the trustee, and he'd be the grantor. Now, in that scenario, based on what we covered tonight, if the IRS is the trustee, they would say, well, we couldn't make the payment because, the creditors would take it from the beneficiary. Is that correct?
Yeah, they might come after it that way, but then they have to expose that it's under discretionary trust.
I'm sorry?
Then they would have to disclose and prove that it was under discretionary trust. That would be, exposing too much truth.
Oh, okay. So that would mean like they would be a stop from taking that position because they would have to expose it in the public. Unless they came in chambers and proved it that way. But the
thing is, who's the grantor on the whole thing? If they're fictions, had to be a real live man's signature someplace.
Exactly, right.
Now, whoever the grantor is, the real live man, he can come back in and change things around as it being misconstrued, and he can bring it in as his intent and purpose because everything was a mistake.
Right. So it's imperative in that case, in his case, to state the trust to his advantage.
Yes, because he's the one that can say it was not a discretionary trust. They're construing it as a discretionary trust.
Right, and they're giving him the window to take it by
Grantor has the total law of the trust case.
Right.
Whatever he says goes. All we got to do is know what to say.
So in his case, right now he could say he has to go there next week. I mean, is there some type of a temporary restraining order or something he could do in order to get that written out correctly?
Are they taking his property? I don't know. He had some kind of summons for a hearing.
He had a summons for a hearing and they put a lien on his property.
Yeah, I don't know if they're selling the property or not, but I know he's got a summons to come in.
Well, that's what I'm saying. If he's got to go there, he was calling because he needed some help to...
Yeah, he would need to start forming the information that there was a trust form and that he's got the information that he's the grantor or the records.
So he would use their letter, their offer to him as the trust res?
Well, it's going to come back to, the signature is the grantor.
So he would use his 1040 original, or what would he use?
Quite possibly. That one's setting it up as trustee, though. See, they may be forming another trust off of that, and that trust would be, say, the lien.
That's what he said. So it was on a lien. He observed that, but he didn't sign. He didn't sign the lien papers.
No, right. That's the thing. Who did, though? Did they get his signature by combination signature rights under a statutory trust?
Probably so.
So now, if he could come up with the records that he was the signer and the creator of this statutory trust that they're the trustees on, and then if he could verbally say that he's the beneficiary and he's the one supposed to get the payment, and this is all a statutory trust anyway, so he can bring this in colorably on the public side without any fear of waiving anything because it's all out in public anyway.
And then he would also ask them to prove their claim by signature, right? He'd want to know, let me see my signature on that, wouldn't he?
Yes, well, you could come in and say, okay, it's obvious by the information that you brought forward that you're the trustee, claiming you're a trustee. Now, I want to do a discovery and find out who's the grantor. Tell me who the grantor is on this trust. If you're claiming trust, you can work it in reverse. The United States is claiming trust. Make them prove trust.
Oh, I got you. Right. Okay. Because they are committed by their own language, right?
Who claims trust must prove trust. Obviously, they're claiming a trust. Now prove it.
So then Connecticut could, between now and then, just make that particular, will be a motion or whatever it is, or you said discovery, and say, look, I need to prove this a trust. Prove this that you have the authority by this trust.
Yes, right.
What instrument would he use for that? What name would it be?
Well, under a court setting would be discovery.
Oh, okay. So Connecticut could take that. He could do that between now, let's say next week, right?
Yeah, he could come up with a court action and make them prove up the trust.
Oh, sounds exciting.
Okay, another question?
Yeah, also, on Saturday we're talking about UCC 1 and 3 with the beneficiary. Now, if I'm the beneficiary and I'm the grantor, do I still need to give myself a UCC 1 and 3?
That's if you're going to transfer the beneficiary's rights, say, to the trustee.
Okay, so if I were going to do that to terminate the trust, I would still have to do that?
Yeah, see, the first set of 1s and 3s was in the formation of the trust res by moving the title of the res to the trustee. That formed the trust. Now, if you want to terminate the trust, you have to transfer beneficiaries' right to the trustee and then terminate the trust on a second set of 1s and 3s.
Okay, so that's just a matter of procedure, irrespective of whether it's...
If that's what you want to do.
Yeah, I mean...
You might not want to terminate the trust. You just might want to make a payment.
Right, right.
You might want to just make a special deposit.
Well, then we discussed also that the special deposit would be there anyway.
Well, see, I can always add more trust res to the trust.
Right. I see that.
Use it as a payment, as a special deposit.
Right.
Without terminating the trust.
Exactly. Which might, in some cases, might be the best move.
Yes, that's what I'm saying. You know, we have so much leeway in technique, and it all depends on skill.
And knowledge.
Yes. Skill is knowledge.
Okay. Well, thanks a lot. That's a good one. I like that. Thanks.
That's it, Christian.
Okay.
You want to end it for the night?
Yeah, might as well. It's after 10, so.
Okay. All right, folks. Thank you so much for joining in with us tonight. Learned a lot of neat new things, and be sure to tune in next Wednesday night, same time, 8 p.m. Central Time or Eastern Time. And until then, have a great evening, everyone. A great week. And Christian, thanks again for everything that you've taught us and are teaching us in the future.
Everybody have a great week. See you Saturday. Thanks, Matt.
Thanks, Christian. Good night.